So Michael Popak, Legal AF, we got some breaking news. Just as we anticipated, Donald Trump has wasted no time and has decided to take a page right out of Clarence Thomas's concurrence, or several pages, and argue to Judge Aileen Cannon in the Mar-a-Lago espionage and obstruction of justice case that Donald Trump's entire case and indictment in Mar-a-Lago should be dismissed because the special counsel is invalid, is improper, is unconstitutional, that he was not properly appointed, and therefore the entire indictment and his prosecution of the case should be invalidated. We knew this was coming. As soon as we saw the concurrence several days ago in Justice Thomas's support for the immunity decision, Trump versus the United States, which effectively gave absolute immunity for all core and effectively all official conduct of whoever is holding the office, and particularly Donald Trump. As soon as we saw that the entirety of the concurrence by Thomas, even though not adopted by the majority, was to argue that Special Counsel Jack Smith should be invalidated, his powers are unconstitutional, and therefore the entire indictment should fall by the wayside. We were just counting the days until Donald Trump and his lawyers got around to informing Judge Cannon about this ruling and this concurrence, and tried to argue for the logic of the concurrence to be applied to a motion to dismiss she is currently considering. Remember, and if you didn't know this before, let me bring you up to speed. After a series of motions brought by Donald Trump against the Mar-a-Lago indictment, even though that indictment is over 2 years old, Judge Aileen Cannon is just getting around to deciding these issues now, mainly because she's trying to benefit him with the timetable so that we get him over, she gets Donald Trump over the November 5th election. Now, she's decided that she finds it very interesting, she said a week or two ago, as to whether Jack Smith was properly appointed and whether his special counsel prosecution office is valid or invalid. And at the time, we reported on it, and it said, well, she asked some questions and she wanted some further briefing on it and all of that. But now, right on cue, we got a new filing. Let's put it up on the board. President Donald J. Trump's notice of supplemental authority. This is what you do in federal court and other courts when you get a ruling you think's in your favor somewhere else. Maybe it's the highest court of your state or the Supreme Court of the United States or even a concurrence. You point it out by filing a notice of supplemental authority saying we have a pending motion to dismiss, arguing that Jack Smith doesn't have powers, and we've got a Supreme Court, at least one justice of the Supreme Court who believes that as well. Here's what they say, and then I'll read to you from the actual concurrence of Justice Clarence Thomas, and then I'll talk to you about the difference between majority opinions, concurrences, and dissents, and their precedential, P-E-R-E-C-E, precedential powers of persuasion. President Trump respectfully submits this notice regarding the impact of Trump versus the United States on pending motions relating to presidential immunity and the appointments and appropriations clauses. Trump, the case, guts the office's position that President Trump has no immunity and further demonstrates the politically motivated nature of their contention that the motion is frivolous. Remember, this is after the guy left office, not before he left office. After he left office and he was no longer president, I don't believe he's going to continue to have absolute or other types of immunity by this United States Supreme Court. Let's set that aside for a minute. They then say that Justice Thomas's concurrence in Trump in the case adds force to the motions relating to the appointments and appropriation clauses. Justice Thomas cites Justice Scalia's Morrison dissent, that's Antonin Scalia, who passed away several years ago, in which is consistent with Justice Kavanaugh's comment and oral argument that Morrison was one of the court's biggest mistakes. Highlighting grave separation of powers concerns, Justice Thomas suggested that 28 U.S.C. 515 and 533, which has to do with the special counsel, do not establish by law Jack Smith's position under the appointment clause. They don't even call him the special counsel. Now it's just Jack Smith. By extension, these statutes are not other law under the relevant appropriation, and these essential questions should be addressed before proceeding. That's it. That's what they say to try to put this on the judge's radar. Now, let me read to you from the first few pages of the concurrence. Then I'll talk to you about the value or weight of such a concurrence. Justice Thomas said on July 1 of 2024, I write separately to highlight another way in which this prosecution may violate our constitutional structure. In this case, the Attorney General purported to appoint a private citizen as special counsel to prosecute a former president on behalf of the United States. But I am not sure that any office for the special counsel has been, quote, established by law, capital L law, as the Constitution requires in Article 2, Section 2, Clause 2. By requiring that Congress create federal offices by law, the Constitution imposes an important check against the president. He cannot create offices at his pleasure. If there is no law establishing the office that the special counsel occupies, then he cannot proceed with this prosecution. A private citizen cannot criminally prosecute anyone, let alone a former president. And then Thomas lays out his interpretation of the appointments clause and all of that. So once we read that, and by the way, no other justice joined in that concurrence. But once we read that, we were like, two reactions. One, why is Thomas even participating in the vote related to this decision and circulating a concurrence? He should have recused himself because of the involvement of his wife in Jan 6th overthrow activities. Putting that aside for a minute, when we saw the front and center was his argument that supported, it was obviously written and directed to Aileen Cannon, the federal judge in Florida, we knew the jig was up. We knew that the fix was in. And right on cue, like in a call and response, we get a filing just 4 days later, one day after the holiday, in which they point to the concurrence. Now look, the majority opinion is the law of the land. Doesn't matter if it's 5-4, 6-3, or 8-1, or 7-2, or 9-0. It is the law of the land. When you have multiple concurrences and even dissents, where do they fit into history? Well, at the moment, only the majority opinion matters, and only what's listed there. If you need to have some amplification, sometimes district courts will look at a concurrence, especially one joined by others, to see if there's any further information or color around the majority opinion. But the majority opinion, the decision of the court, is the decision of the court. It is the precedent to be followed and no other. You can point to elements of a concurrence, but it is not precedential. And I mean precedent, not president. It is not binding law. It is interpretive. It can be persuasive. But there's limits to that depending upon how many people join and anything else. Now, look, the majority opinion did not address at all the special counsel's special powers and him being delegated and him being appointed and being given a budget. And by not mentioning it, they implicitly endorsed it. That's my interpretation, 6-3. But then you've got Tom, and I'm sure that's what the special counsel, Jack Smith's office, is going to say. Majority opinion saw Clarence Thomas's concurrence and did not bite at it, did not address it, did not mention it, did not have a section in the majority opinion that says that the special counsel is invalid. And in fact, even though it was addressed, did not invalidate the prosecution. And so that should be the majority opinion. Just as the concurrence by Amy Coney Barrett and others is not the law of the land. Neither are the dissents. Now, what happens in history is that as the court evolves and some of these things get changed, sometimes what was the dissent, people recognize should have been the majority opinion, and it gets cited favorably in the future. Just as I think Justice Sotomayor's very passionate and intellectually honest assessment of the immunity ruling will be seen as what should have been the majority opinion in the future. Like, I've seen footnotes take on a life of their own in Supreme Court decisions, whereas the whole opinion gets ignored, but a footnote becomes the thing that drives the law in the future. But what we're watching, and you're going to see an interview that I just did of Judge J. Michael Luttig, who's a firebrand, an icon, defender of the Constitution, a Federalist who's a conservative, who's appalled and aghast at the scar that's just been placed on our democracy by the immunity decision. And in our interview as well, he says it's very clear that the majority started with the proposition that they were going to give absolute immunity one way or the other to a person named Donald J. Trump, and then wrote and reversed engineered a decision, a sloppy, intellectually dishonest decision that the judge said was about as good as a first-year law student's moot court brief in law school, and that's what they were trying to do. This entire opinion, even though it's now with us for the foreseeable future, was written only to benefit one person, a candidate named Donald J. Trump and a former president named Donald J. Trump. And so he called it out for what it is, that this court, Alito, Gorsuch, Thomas, and even Roberts, joined by Amy Coney Barrett and Kavanaugh, are speaking to the trial judges, including Aileen Cannon, and signaling to her and to strengthen support for arguments for Donald J. Trump. Even though we're now stuck with this creation of an imperial president, almost without limit from a criminal prosecution standpoint, we're now stuck with that forevermore, beyond Donald J. Trump. And so we're going to continue to follow what now Aileen Cannon, hearing the dog whistle that was placed into the Supreme Court decision by the concurrence of Thomas, now brought to her attention, of course, right on cue by Trump, what she does next. If I had to venture a guess, she's going to say that the intellectual interpretation and constitutional scholarship embedded and embodied within Justice Thomas's concurrence, although not part of the majority decision, is right. And I think Jack Smith was improperly delegated authority and doesn't have his budget appropriately appropriated to him, and the whole indictment should go out the window. And let's send it back to the Supreme Court. While you have the Special Counsel's office jumping up and down, fortunately it goes to the 11th Circuit first, jumping up and down and saying, what are you talking about? The majority had an opportunity. They had seen Thomas's concurrence. They had an opportunity to either adopt that as the majority opinion or to reject it, and they rejected it. In fact, the entire underlying premise of the new majority opinion is that the prosecution is valid, but may be going after crimes that are immune. That's different than arguing that the special prosecutor is invalid and illegal and beyond the constitutional powers. That is completely different. So we'll continue to follow everything just the way we do at the intersection of law and politics right here on the MeidasTouch Network and on our show, a podcast we call Legal AF. Now you know why we named it that 4.5 years ago. It's for moments just like this. So if you like it, you can tune in Wednesdays and Saturdays, 8 p.m. Eastern Time. And then right here on this YouTube channel where you can free subscribe and then pick us up on all major audio podcast platforms. I got a special interview with J. Michael Luttig, former federal judge, and again, just a lion of the Constitution. And you're going to see how apoplectic he is about the decision. And he calls it out for what it is, which is just reverse engineering to benefit one person named Donald J. Trump by the right wing of that court, a court that he says can no longer be called conservative when they're just trying through judicial activism to benefit a person politically. And we'll follow it all right here on the MeidasTouch Network and on Legal AF. In the meantime, I'm Michael Popak, Wednesdays and Saturdays at 8 p.m. Eastern Time. You can follow me right here on the MeidasTouch Network and on hot takes just like this one. So until my next hot take, until my next Legal AF, this is Michael Popak reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.